Very well, my lord.
So this is the judgment between Mr. Nesta Garba and Heritage Bank PLC. The claimant instituted this suit by way of a general form of complaint filed on the 13th of June 2023, seeking the following reliefs against the defendant. 1. A declaration that the claimant's employment having not been formally terminated till date, the claimant is still in the employment and or payroll of the defendant and is entitled to all his remunerations. 2. A declaration that the actions of the bank by refusing to pay the claimant's salary is wrongful and unlawful. 3. An order of the Honorable Court directing the defendant to pay the claimant his salary and other financial entitlements from April 2015 till date. 4. General damages in the sum of 5 million naira as compensation for the emotional trauma, aggravated stress, and psychological agony caused the claimant. And 5. Interest at the prevailing commercial bank rate on the sum arrived at in relief C and D above before judgment, and thereafter 10% until the judgment sum is liquidated. The claimant's case. The claimant's case is that he was employed in June 2001 as an office assistant at the defendant's branch office in Jos Plateau State. At the time he was employed, the bank was operating as Citizens Bank. Its name was changed to Spring Bank, the Enterprise Bank, and finally Heritage Bank. The claimant attained exceptional feats while he worked and earned the branch office top position as overall balance sheet and earned promotion from OA3 cadre to C1 cadre in 2005. He was awarded several commendation letters and cash awards. By his performance review, he achieved 268,587,897 naira as against the target of 50 million naira. He was confirmed as a core staff in December 2011. In 2015, he noticed discrepancies in an account and he flagged it to his superiors, but was not heeded to. In April same year, 2015, he was arrested on false accusation of aiding a customer to defraud the bank. He was detained and suffered from non-payment of salaries. He was never queried, warned, or reprimanded or terminated. His solicitor wrote a demand letter and a reminder for outstanding salaries, and there has been no response. Claimant tendered 8 number documents as exhibits and they were admitted in evidence and marked as Exhibit C1 to Exhibit C8. Exhibit C1 is the approval for exceptional promotion. Exhibit C2 is the promotion recommendation/justification. Exhibit C3 is recommendation for exceptional promotion. Exhibit C4 is recommendation for Nesta Garba promotion. Exhibit C6 is performance review. Exhibit C5 is performance review. Exhibit C6 is confirmation of appointment. Exhibit C7 is a letter of demand. Exhibit C8 is a reminder of demand. The defendant's case. The defendant, on the other hand, filed his statement of defense on the 5th of March 2024. And on the 25th of April 2024, his application for a deeming order that his memo of appearance, statement of defense, and other accompanying processes already filed, they were duly filed and served, was granted by the court. The defendant denied that the claimant was a staff, neither did he attain exceptional feats for the defendant, neither did he earn promotion or was awarded commendation, that he was never confirmed, that the claimant never noticed a discrepancy in any account as there was no report of such by the bank and there was no account flagged by the bank, that rather on the 8th of April 2015, due to a protest letter received by the bank from a certain Mr. Churchill, MD of Westgate Global Trust Limited, the claimant was accused of receiving money under false pretense and involved in private foreign exchange transaction between Mr. Churchill's company, who was the buyer, and a seller, Don and Chike Limited, for the purchase of 1 million contrary to CBN guidelines. Mr. Churchill petitioned law enforcement agencies, and the claimant was arrested for misappropriation of funds and was already in police custody at the instance of Mr. Churchill, so he could not be reached for comment. That the bank made it clear to Mr. Churchill and the other customer involved in the forex transaction that since the bank was bypassed, it was not liable to either party since the transaction involved was a private business. The claimant was sent on indefinite suspension pending interface with the staff disciplinary committee for fraudulent transfers. After his release from police custody, the claimant did not report to work exceeding 72 hours, so his action was treated as abandonment/absconding, which is a sanctionable infraction by Section 415 of the Human Capital Policy Manual. That the claimant was paid April 2015 salary preceding his arrest. The arrest and detention of the defendant was 8 years ago in 2015, which is over 6 years and therefore statute barred, and the reliefs are not sustainable in law. That was the case of the defendant. In the claimant's reply, he denied that he was ever in any misappropriation transaction, forex transaction between Westgate GTL and Don and Chike Limited or any person at all. That the defendant bank never received any protest letter from a certain Mr. Churchill, and no query or suspension letter was presented to him, and he was not aware of any investigation by Heritage Bank in respect of Mr. Churchill's complaint. That he was detained because he was the account officer of the customer who transacted with the said Mr. Churchill. After his release, he reported to work, but the security officer denied him access. The manager asked him to await his call before resuming for duty, and he was not aware of any disciplinary action. Since he never got a specific date to resume from the branch manager on the several occasions he called, he contacted his counsel to demand for his outstanding salaries. By the order of court, the claimant filed its final written address on the 29th of November 2024, the court's decision. Though the defendant herein abandoned its defense, it had in its statement of defense raised the special defense of statute barred. As mentioned earlier, the defendant stopped coming to court and did enter his defense as per its statement of defense, but the court is empowered to look at documents constituting its records. The issue of statute barred being a jurisdictional issue cannot be glozed over by the court, for any proceedings conducted without jurisdiction will amount to a nullity, no matter how well conducted. It is for this reason the court will consider this issue in order to determine whether or not the claimant's action as presently constituted is statute barred. Being an issue raised in the defendant's pleading, it is such that the claimant cannot, with respect, feign ignorance of. In other words, it is the considered view of this court that consideration of this issue at this stage will not amount to infringing on the claimant's right to fair hearing, as it is said, as it is such that emanates from the parties' pleadings. Where the law prescribes a period for the institution of an action, proceedings shall not be commenced after the stipulated period, as the right of the injured party to commence the action would have been extinguished by such law. See Awolola versus Governor of Ekiti State, citation provided. A cause of action is said to abate or is statute barred when no proceedings in respect thereof can be initiated because the time specified by the limitation law has expired or extinguished. For the purpose of determining the period of limitation, the court looked at the writ of summons and statement of claim to ascertain when the cause of action accrued. From paragraphs 11 to 15 of the claimant's statement of fact, the material facts which entitles the claimant to maintain an action against the defendant arose not earlier than sometime, and I quote, sometime in April 2015, end of quotation. And the claimant's action was filed on the 13th of June 2023. The issue of limited action is the issue of limitation law is a jurisdictional matter that can be raised at any time, even in the absence of the claimant has filed a statement of event which was deemed properly filed and served on the 28th of April 2024. When it comes to the issue of jurisdiction, the question whether or not the court has jurisdiction to entertain a suit is a radical and crucial question of competence. And when it is raised, it is neater, better, in fact, imperative to settle that issue one way or another before proceeding to hearing of the case on the merits. See AG Lagos State versus Dusumu, citation provided. There is so much. This is so because jurisdiction is such a fundamental threshold issue that supersedes any other procedural issue. It is the blood of any adjudicatory process, so it can be raised at any point and even verbally for the first time at the Supreme Court, and leave is not required to bring the jurisdictional issue up on appeal. See AJ Printing Nigeria Limited versus Ekiti. An issue of limitation of action is related to the substantive jurisdiction of a court. The issue of jurisdiction can be raised whether or not the party has filed pleadings. The issue of jurisdiction can be raised at any time whether it is pleaded or not. It can be raised by the court summatum and even on appeal. See FCE Oyo versus Akinyemi, citation provided. In Radiographers Registered Board of Nigeria versus Medical and Health Workers Union of Nigeria, it was held that courts should give prime consideration to issues of limitation of action when raised. The issue before the court being one bordering on jurisdiction can respectively be looked into with or without pleadings. The defendant has filed its pleadings and raised therein the issue of jurisdiction, which has to be ruled upon one way or the other. Our case law is replete with authorities that the issue of statute of limitation is a special defense, one that ordinarily should be raised in the pleadings of the party that intends to rely on it, seeking the striking out of a suit. See Ella Banjo versus Dawudu, citation provided, and AJ Printing versus Ekiti local government area. In APC versus Lere, citation also provided, the Supreme Court, in the course of the Supreme Court, on the purpose of limitation period held inter alia, and I quote, where a statute provides that certain actions are to be brought within a prescribed period after the cause of action accrues to the plaintiff, proceedings should not be brought after the time prescribed by the statute. The real purpose of the limitation period is to protect the defendant from the injustice of having to face a stale claim. Limitation is thus the procedural defense. Actions brought outside the limitation period are statute barred. See Ofongo versus APC and Wale versus APC, citations all provided. Similarly, in Kashi versus Gwagwa, citations provided, the Apex Court stated the effect of an action being statute barred is simply that it renders the action barren and sterile and therefore incompetent. It deprives the court of jurisdiction to hear and determine the suit. So where an action is statute barred, hearing and determining it on the merit becomes unnecessary. The trial court acted in obedience to the dictates of the law, end of quotation. Simply put, a cause of action is a subject matter of grievance founding an action in court. That is, the factual situation stated by the claimant, which, if substantiated, entitles him to a remedy against the defendant. See Chevron Nigeria Limited versus Lone Star Drilling Nigeria Limited, citation provided. That is, a cause of action is a complaint of violation of a civil right or obligation arising, giving rise to an enforceable claim. It is a dispute in respect of which a court of law is entitled to invoke its judicial powers. See Yare versus NSWIC, citations all provided. From the claimant's pleadings, it is obvious that the grievance founding the claimant's action is in respect of a lack of a formal termination of his employment and refusal to pay salary. To ascertain whether this court is seized with a requisite jurisdiction to entertain this as presently constituted, this court is bound to examine the claimant's general form of complaint and statement of fact vis-a-vis the enabling statute. See LLSPIA Limited versus MT Tuna, and ISA versus INEC, right? Like citations all provided. Paragraph 11 to 15 of the claimant's statement of fact is apt as it relates to determining when the claimant's cause of action arose. It reads, and I quote, paragraph 11. Sometime in April 2015, the claimant was arrested at the defendant's premises by law enforcement agencies on a false accusation of aiding a customer of the defendant to defraud a company. Subsequent paragraphs in the claimant's pleading made mention of the fact that he was released after some years, and when he resumed in the defendant's premises, the security men denied him access, and he was informed to await the call of which he never received, culminating in this suit. Given the facts and the instant suit, to determine when the claimant's cause of action arose, consideration would be given to the following in view of the claimant's pleadings. When was the claimant arrested? When did the claimant resume duty, and was his salary restored, if any? Is the non-payment of the claimant's salary a continuing injury? Which, from the claimant counsel submission and the entire circumstances of the case, the claimant's cause of action arose, and I quote, sometime in April 2015, when he was arrested by law enforcement agencies. The defendant did not expressly mention the date of the arrest, but that on the 8th of April 2015, the defendant received the petition from his customer accusing the claimant of obtaining more forex transactions against CBN guidelines, which I'm sorry, the network cut me off. Can you hear me now?
Very well, my lord. I can hear. I can hear
Can you
you.
hear me?
Very well, my lord. Very well.
Okay. So from the learned claimant submission and the entire circumstance of the case, the claimant's cause of action arose, and I quote, sometime in April 2015, when he was arrested by law enforcement agencies. The defendant did not expressly mention the date of the arrest, but that on 8th of April 2015, the defendant received a petition from a customer accusing the claimant of owing money under false pretenses and engaging in forex transaction against CBN guidelines, which led to his arrest and detention, and the claimant never returned to answer to a disciplinary panel. The case as put forward by the claimant seems to be that indeed he was arrested sometime in April 2015. And throughout his years in detention, he was neither paid salary nor notified of any query or warning, for which he filed this suit on the 13th of June 2023, seeking remedies before this court. The claimant's pleading is not categorical on the date of arrest, date of release, or date of resumption. Citations also provided. The Supreme Court had this to say in relation to when a cause of action, and I quote, in the instant case before his retirement from service, the appellant fought hard to ensure that the deductions of his salary was refunded in 2020 benefits. On 3rd September 2004, he discovered that his benefits were computed on grade level 14 instead of grade level 15 when he allegedly retired. That was when his cause of action arose. He commenced the action on the 18th of July 2008, more than 2 years after the accrual of his cause of action. End of quotation. In the case under reference, the apex court was of the view that the period of negotiation did not stop the period of limitation from running. This brings us to the last poser then. Is the non-payment of payment a continuing injury which has not been remedied by the defendant? The Limitation Act provides that suit not having been commenced within 6 years of the incident in Durham versus NNPC, the Supreme Court had this to say on exceptions to statute of limitation, and I quote, legal principles are not always inflexible. Sometimes they admit of certain exceptions. The law of limitation of action recognizes some exception. Thus, where there has been a continuance of the damage, a fresh cause of action arises from time to time as often as damage is caused. A situation where the person relying on it acted outside the color of his office or outside his statutory or constitutional duty, end of quotation. So where from the claimant's pleadings, his cause of action reveals that the defendant acted in abuse of office or maliciously or with no semblance of legal justification, the exception may apply. See AG Rivers State versus AG Bayelsa citation provided. The claimant alleges that he is entitled to his salary arrears, which is being withheld by the defendant, and it would be unconstitutional under the guise of any law to deprive the claimant of such benefit. In other words, from the claimant's pleading, though it may be deciphered that the non-payment of the salary by the defendant has made the benefit he is ordinarily entitled to altered to his disadvantage and is being withheld, the claimant's pleading, in my respectful view, has not shown that this act or conduct of the defendant is of a recurrent nature, thus constituting a continuous injury or damage which has not ceased. See Abba versus Board of Directors, NIPO Supra. Although the Supreme Court has held that the denial of a party's pension is a wicked and unacceptable act when same has been earned, and that a statute of limitation is not for witch hunting and vendetta. Limitations law allows that bar the enforceability of a claim against a specified period, a claim after a specified period. It establishes a time limit for suing in a civil case based on the date the claim accrued. The purpose of such a statute is to require diligent prosecution of known claims, thereby providing finality and predictability in legal affairs. The purpose of limitation, like equitable doctrine of laches, is their conclusive effects is to promote justice by preventing surprises through the revival of claims that have been allowed to slumber. Having already found, as noted earlier, that the claimant's cause of action is largely centered on withheld salaries, and that from the claimant's pleading, he discovered his right to receive his salary was being breached by the defendant, it follows that his cause of action accrued when his right to receive his salary arose and the defendant failed to pay him. The claimant should have instituted an action against the defendant timeously. Now, as it stands, the claimant's call for intervention on this matter took almost 8 years difference from the initial date of arrest. In the instant case, although correspondences were exchanged by the parties to have the issue resolved in 2023, the claimant pursued the path of negotiation late. The defendant, it appears, never responded to the correspondences, neither did they admit liability. The claimant should have acted immediately he was released from detention, even though his date of release was never made known to this court. By approaching the court to seek a remedy to the alleged So since the claimant's date of release was not made known to the court is therefore left to speculate when he was released and when the suit was instituted. From between the years 2015 to 2023, when the claimant instituted this action, is about 8 years. Given the facts and the circumstances of the instant suit, I find and I hold that the claimant's suit was filed well after the limitation period set out by the limitation law of Lagos State. I so find and I so hold. On the whole, this suit is being statute barred and is hereby dismissed, I so hold. However, in the event that the above decision of this court is found to have infringed on the claimant's right to fair hearing, the court will proceed to consider the claimant's case on the merit and reach a decision on same one way or the other. The court observed that for reasons best known to the counsel to the defendant, he was in court for the last time on the 25th of April 2024 after filing and regularizing his statement of defense and witness statement on oath. Defense counsel was also absent on the day set for trial, which was on the 11th of July 2024. The matter was adjourned to the 13th of October 2024 for trial. The claimant opened his case, adopted his witness statement on oath, and tendered his exhibits. The case was adjourned to the 28th of November 2024 for continuation of trial. At the sitting of 3rd of December 2024, learned claimant counsel applied to foreclose the defendant from entering his defense and for an order to file and adopt his final written address, and the court granted the order. On the 14th of January 2025, the learned claimant counsel adopted his final written address and the case was adjourned for judgment. The claimant is before this court seeking for two declarations. One, a declaration that the claimant's employment having not been formally terminated till date, the claimant is still in the employment and or the payroll of the defendant and is entitled to all his remuneration. And secondly, a declaration that the actions of the bank by refusing to pay the claimant's salary is wrongful and unlawful. The state of the law with respect to declaratory reliefs are clear. In Elechino Obe versus MTN Nigeria Limited, the court put it aptly thus, and I quote, it also settled the authorities that the declaratory relief, being discretionary in nature, the onus of proof lies on the claimant, and he must succeed on the strength of his own case and not on the weakness of the defense, except where the case of the defense supports the appellant's case. Thus, the burden of proof on the plaintiff in establishing declaratory reliefs to the satisfaction of the court is quite heavy in the sense that such declaratory reliefs are not granted even on admission by the defendant. In the event that the plaintiff fails to establish his entitlement to the declaration by his own evidence, an applicant must therefore adduce sufficient, cogent, and credible evidence in support of his claim. In fact, declaratory relief is not even granted on admission of the other side. Thus, an applicant for a grant of declaration must either on the strength of his case rather than on the weakness of the case of his adversary. Asserting without proof is nothing but mere exercise in futility. Declaratory reliefs are not granted based on the lack of credible evidence by the defense, but on the convincing, satisfactory, and credible evidence by the claimant by relying on the case of Adamo versus Nigerian Air Force. Citations all provided. So far, the fact that the defendant entered appearance and filed his process did not cross-examine the claimant does not absolve the claimant from proving his case to the satisfaction of this court, given the minimal evidence rule, which is that a plaintiff cannot assume that he is entitled to automatic judgment just because the other party did not adduce evidence before the trial court. See Attorney General Osun State versus NLC and others, Mr. Lawrence Azenabo versus Bayero University Kano, Ogunyade versus Oshukeyen, and Shell Development Company of Nigeria Limited versus the Minister of Petroleum Resources, unrepeated suit number NISLA 178/2022, the judgment of which was delivered on the 28th of July 2022. The claimant maintains that his employment has not been formally terminated till date. In proof of in paragraph 15 of his witness statement on oath, that throughout his years in detention, and I quote, the defendant neither paid my salaries nor notified me of any query, warning, reprimand, or termination. Also in his further witness statement on oath, paragraph 2, he averred any investigation by the bank in respect of a customer's complaint, in bracket Mr. Churchill. And in paragraph 16, he averred he was never suspended nor presented with a letter of notice of suspension. It is also his case that after he was released from custody, he reported to the defendant's just branch and was denied access into the workplace by the security officer He was told to await instructions to resume from the branch manager, but he was never given a date to resume. Therefore, his failure to resume was as a result of the defendant's failure a date for him to resume. As earlier stated, the defendant only filed his statement of defense and did not appear in court. After that, however, relying on Agbasi versus Ebi Kofere citation provided, where the court held that the courts have absolute power to look at the documents in their files and utilize them to support established facts, and Uzodin Zima versus Izuanasu citations all provided. In the statement of defense, the defendant stated that after the complaint from the customer on the claimant, an investigation was done in paragraph 9, but the claimant could not be reached for comment as he had been arrested and was in police custody at the instance of the complainant. In paragraph 13, the defendant was sent on indefinite suspension pending interface with the staff disciplinary committee. On his release in paragraph 16, the defendant claimed the claimant failed to return to his work in a bid to avoid disciplinary actions against him in violation of the Human Capital Policy Manual. Claimant was deemed to have absconded from duty. The last salary paid to the claimant was for April 2015, preceding his arrest and detention. This fact was confirmed in paragraph 25 of the claimant's further witness statement on oath. The claimant tendered in proof of this declaration that his employment having not been fully terminated till date, therefore he is still in the payroll of the defendant, approval for exceptional promotion, promotion recommendation, performance review, confirmation, letter of demand, and reminder of demand. Both parties did not tell this court how long claimant was in police custody. Parties are in agreement that he was indeed incarcerated in the month of April 2015, and he was paid for that month. Civil cases are won on preponderance of evidence, and it is the duty of the trial court to weigh the evidence of parties on the imaginary scale of justice and give judgment to decide whose evidence weighs more. See Grief VL Containers PLC versus OP and Industry Limited. Citation provided. In the circumstance, the claimant did not provide evidence to show that he has been coming to work. There is no evidence of a letter or an email to indicate that he communicated with the manager, telling him of the instruction he gets at the gate and denying him access. Claimant has no evidence before this court to indicate any further step he took to inform the bank branch manager that he was always at the gate and could not gain access into the office. It is tried law that facts deposed to in pleadings must be substantiated and proved by evidence, in the absence of which the averments are deemed abandoned. Aregbe Shola versus Oyinlola, citation provided. It is tried law that a claim for wages cannot succeed for work not done. And I quote, he is, however, not entitled, I hold, to the claim for salary and allowances until 2006. An employee cannot claim for a period that he did not work. See the case of Olatunbosun versus Naisa. And also Springbank versus Babatunde. And Atuloma versus Nigerian College of Aviation. Citations all provided. In the instant case, there's ample evidence that the claimant has failed to prove that he presented himself at his work premises after he was released from police custody. This is a pointer that the claimant, in this court's opinion, absconded from his duty post by section 4.1.5 of the Human Capital Manual Policy and Procedure Manual. I quote, after 72 hours of absence without explanation and efforts to reach the employee / next of kin proves abortive, employee shall be deemed to have abandoned the work, and the steps outlined in termination shall be followed to formalize the exit. In paragraph 13 of the claimant's statement of fact, he stated, and I quote, throughout my years in detention, the defendant neither paid my salaries, end of quotation. I recall that the court noted earlier that the length of time claimant was in detention was never made known to this court. Albeit, this court is not convinced by the facts and evidence laid before this court that the claimant resumed at his duty post after his release from detention. In the entire pleadings, the court noted that the claimant, in proof of his innocence, never presented a police report exonerating him from the allegations while he was arrested and detained for years. The declaration sought that the claimant's employment, having not been formally terminated till date, and the claimant is still in the employment of the defendant, and the action of the bank by refusing to pay the claimant's salary is wrongful and unlawful, fails. In other words, Reliefs 1 and 2 fails, I so hold. Relief 3 is seeking for an order directing the defendants to pay salaries and financial entitlements for April 2015 to date. This relief fails since the foundation on which it stood was unsuccessful. Relief 4 is for general damages of 5 million naira for emotional trauma, aggravated stress, and psychological agony. This relief also fails. Relief 5 is dependent on relief 3 and 4. And relief 3 and 4 having failed, this relief collapses, I so hold. Judgment is entered accordingly, and it is signed. This is the judgment of the court.